to Lecture 4 of the Human Rights lecture series. After watching the previous 3 lectures, we now know what human rights are. We discussed sexual and reproductive health and rights, SRHR, and the human rights related to water, sanitation and hygiene, WASH, more in depth. We have learned that when a state signs and ratifies a treaty, there is an obligation to implement the rights recognized in that treaty. But recognition of rights on paper is not sufficient. In the end, human rights need to be enjoyed in practice. It's now time to find out how implementation of human rights treaties is monitored. In this lecture, the following questions will be addressed. What happens if states fail to respect, protect and fulfill human rights? Which mechanisms exist to put pressure on governments to comply with their human rights obligations? And what is the role of UN treaty monitoring bodies? When we take a look at the work of the UN in the field of human rights, it's carried out by a number of bodies. A distinction should be made between charter-based and treaty-based human rights bodies. Charter-based bodies derive their mandate from provisions contained in the Charter of the United Nations and hold broad human rights mandates. An example of a charter-based body is the Human Rights Council. It was established by resolutions of UN organs whose authority comes from the UN Charter. In addition, it is a subsidiary organ of the General Assembly. The Human Rights Council is an intergovernmental body within the UN system. It consists of 47 states as members. The responsibilities of the Human Rights Council, including the work of the UPR Working Group, will be addressed in lectures 5, 6 and 7. In this lecture, we will focus on treaty-based bodies. During the first lecture, we explained that there are 9 core international human rights treaties that you see listed here again. Examples are the International Covenant on Civil and Political Rights, the Convention on the Elimination of all Forms of Discrimination against Women, and the Convention of the Rights of the Child. Each of these 9 core human rights treaties is monitored by a group of independent experts that we call UN Treaty Monitoring Body. This treaty monitoring body consists of 20 to 25 members who are chosen on the basis of their expertise. The experts come from different countries all around the world. They are nominated by states among their nationals and elected by the whole membership of state parties to the treaty. They are required to act in personal capacity independently from the state that has nominated them. There are currently 10 UN treaty monitoring bodies. Each of the core human rights treaties has its own monitoring body, so that makes 9 treaty monitoring bodies. To give you an example, the Committee on the Elimination of Discrimination against Women monitors implementation of the CEDAW Convention. It has been established in 1981 and it has 23 members who are experts on women's rights. The 10th monitoring body is the Subcommittee on Prevention of Torture, established under the optional protocol to the Convention Against Torture. The mandate of the subcommittee is twofold: to visit all places of detention in state parties and to provide assistance and advice to both state parties and their independent national bodies for the prevention of torture. Now we know that each treaty has its own committee. The next question is, what exactly is the role of treaty monitoring bodies? In the first place, they monitor the implementation of and compliance with their own respective human rights treaty. In the second place, the UN treaty monitoring bodies also publish interpretations of the content of human rights provisions or certain particular human rights issues in the form of general comments and general recommendations. Let us start with the first role of the treaty monitoring bodies, namely monitoring the implementation of and compliance with human rights treaties by the state party at the national level. The question is, how do the committees do that? Well, there are 4 different ways. In the first place, the consideration of state parties' periodic reports. In the second place, the consideration of individual complaints. In the third place, by conducting a country inquiry. And in the fourth place, by interstate communications. Let us start with the first one, the consideration of state parties' periodic reports. This is a review cycle that involves several steps. Once states have signed and ratified the treaty, the government has to periodically prepare and submit reports to the committee. In these reports, they explain how the rights of that particular treaty are being implemented. The reporting period varies between 2 to 5 years, although I must say that, in reality, states often take longer. If you want to find out whether a country is a state party to a specific treaty, you can easily find that information online. You go to the website of the United Nations Human Rights Office of the High Commissioner. Then you go to Human Rights by country. Let us take the United Republic of Tanzania as an example. You can type it in or select a country in the list, and then you see the page of the United Republic of Tanzania with a map of the country, an overview of the ratification status and reporting status. If you click on status of ratifications, you see which of the 9 core human rights treaties have been signed and ratified and which date that happened. You see, for example, that the government of Tanzania signed the CEDAW Convention in 1980 and ratified it in 1985. They signed the Child Rights Convention in 1990 and ratified it in 1991. But you can also see that the government of Tanzania signed the Convention for the Protection of All Persons from Enforced Disappearance in 2008, but that they haven't ratified it yet. As explained in Lecture 1, this means that they haven't become a state party to this treaty. This means that they are not yet legally bound by the treaty. On this webpage, you can also see that Tanzania is among a small minority of countries that have not signed or ratified the Convention Against Torture and other forms of cruel, inhuman or degrading treatment or punishment. The government also didn't sign or ratify the International Convention on the Protection of the Rights of all Migrant Workers and members of their families. When a state has become a state party to a treaty, they have to periodically submit reports to the respective treaty monitoring body. In the case of Tanzania, this means that the government has to submit reports to 6 treaty monitoring bodies. When the committee receives a state party report, the experts study the report in depth and draft a list of issues. This list is sent to the state party, to which the state party replies. Not only the state report is examined, but the committee also receives information from other stakeholders, including UN agencies, other intergovernmental organizations, national human rights institutions, civil society organizations, professional groups, and academic institutions. This means that you, as a civil society organization, can also submit information to the treaty monitoring body. Then, the next step is a full review session, including a dialogue with the state, taking place in Geneva, where the report is considered. The state sends a delegation to Geneva. During this session, the committee questions the state about their human rights record. There is a dialogue between the committee and the state party. The aim of this review session is to assist the state in its efforts to implement the treaty as fully and effectively as possible. After the review, the committee drafts concluding observations. This is an important report with the main findings and recommendations for action. All documents, including the state party report, the contributions of civil society organizations and other stakeholders, the concluding observations, and recommendations for further action can be downloaded from the website of the Office of the High Commissioner of Human Rights. Let me explain how you can access those documents by taking Tanzania again as an example. You go back to the webpage of the United Republic of Tanzania. This time you don't click on status of ratifications but on reporting status. Then we click on the CEDAW Convention and you will see the reporting cycles. If you click reporting cycle 7 to 8, you see that the state party's report was submitted in November 2014. When you click View Document, you can download the report in 6 different languages. When we go back, you see also the list of issues, the reply to the list of issues, information from civil society organizations, the concluding observations and summary records. In addition, the sessions are also available online on the website webtv.un.org. The final step in the reporting cycle is for the state party to implement the concluding observations. Perhaps good to know, these concluding observations are not legally binding on states parties. This means that the effectiveness often depends on the voluntary compliance of states. However, you, as a civil society organization, can use the recommendations of treaty monitoring bodies to encourage your government to take action, for example, to publicize them. Apart from the consideration of states parties' periodic reports, the UN treaty monitoring bodies can also consider individual complaints. It is perhaps interesting to know that thousands of people around the world submit such complaints every year. However, not in all circumstances you can bring a complaint to the attention of the United Nations, as several conditions apply. First of all, this procedure is optional for state parties, which means that states must have ratified the treaty. But apart from that, the state must also have recognized the competence of the committee to deal with individual complaints, for example by accepting an optional protocol or by making a declaration. Another requirement is that local remedies have to be exhausted. So first, all national legal avenues have to be used. The next question is, who can complain if these conditions are met? Well, anyone who claims that his or her human rights under a treaty have been violated by a state party. But there are a few additional requirements. For example, the individual has to be personally and directly affected. The violation must refer to a specific treaty provision. The claim needs to be sufficiently substantiated, and the event should not have occurred before the entry into force of the treaty. Then we move to the third way in which the treaty monitoring bodies monitor the implementation and compliance of human rights treaties, namely country inquiry. 6 out of 9 committees may, under certain conditions, initiate inquiries if they receive reliable information about serious, grave, or systematic violations of the rights that are enshrined in the respective treaties in a state party. You see those 6 committees listed here. It is important to mention that, as was also the case with the individual complaints procedure, states must have recognized the competence of the committee to do this before they can initiate such procedure. What does the inquiry procedure look like? Well, first of all, the committee invites the state party to cooperate in the examination. Then the committee may decide to designate one or more of its members to make a confidential inquiry and report urgently to the committee. After the inquiry, the findings of the members are examined by the committee and communicated to the state party with comments or recommendations. Then the state party is required to submit its own observations on the findings of the committee. Important to note is that the procedure is confidential. I would like to give you an example. In 2011, the CEDAW committee received information from 3 civil society organizations, of which one is Equality Now, that Mali is committing grave and systematic violations of the rights under the CEDAW Convention. These organizations stated in the first place that Mali has failed to fulfill its duty to protect women and girls in the territory against female genital mutilation. In the second place, Mali has failed to fulfill its duty to prosecute and punish those who carry out FGM. In 1985, Mali had ratified the CEDAW Convention and acceded to the optional protocol in 2000. 3 members of the CEDAW committee visited Mali in December 2018 to conduct a confidential inquiry. The main problem is that the government of Mali hasn't criminalized the practice. In other words, there's no law in Mali that prohibits FGM. In June 2020, the committee published a report in which they concluded that the state is responsible for grave and systematic violations of various rights under the CEDAW Convention. They recommended the government of Mali to take several measures for the protection and effective recognitions of the rights of women. More specifically, the committee recommended, for example, to adopt, without delay, a law criminalizing FGM, to develop a strategic plan to implement the law, to establish a national coordination mechanism, and to provide appropriate specialized care to girls and women who have undergone FGM. Let us then move to the 4th way in which committees can monitor implementation and compliance. 5 human rights treaties allow their state parties to complain to the relevant committee about violations of another state party. However, this procedure has never been used. Then we navigate back to the main roles of treaty monitoring bodies. Apart from monitoring the implementation of human rights treaties, the committee also develops general comments and recommendations. These are based on their experience in monitoring the treaty provisions and meant to give guidance to states on how to best implement the treaties. Here you can see an example of a general recommendation adopted by the CEDAW Committee. It is General Recommendation number 35 on gender-based violence that was adopted in July 2017. In this document, the committee provides further guidance to states on how to accelerate the elimination of gender-based violence. For example, the committee explains in this general recommendation that the prohibition of gender-based violence against women has evolved into a principle of customary international law. In addition, the committee urges states parties to strengthen the implementation of their obligations in relation to gender-based violence against women, whether within their territory or extra-territory. All right, we came at the end of Lecture 4. In this lecture, I have elaborated on human rights mechanisms. I explained what UN treaty monitoring bodies are and discussed their different roles. I explained the 4 ways in which they monitor implementation and compliance with the human rights treaties. I also explained that treaty monitoring bodies develop general comments and recommendations. The next lectures will focus on the Universal Periodic Review. The UPR complements the work of the treaty monitoring bodies. Thank you for your attention.